Number on CRM NDPS all of 2025.
Lord, I appear for the petitioner, my Lord. Lord, this is an application under section 483 of BNSS 2023, my Lord, for bail.
What is the recovered substance?
My Lord, it's cannabis weighing around 4.07 kgs.
Oh,
It is an intermediate quantity. The charge sheet has already been filed and
for
CD case diary as well.
the accused have already been granted.
but you don't dispute the quantity. It's just more than
It's small.
small and much less than commercial.
Up to 1 kg.
And his custody is how long?
Lord, he is there in the judicial custody for the last 95 days. My Lord.
Charge sheet has been submitted.
As per the.
Charge sheet has been submitted. It is there reflected.
You find out.
Plus.
Land State Council submits that he would inquire whether charge sheet has been submitted or not. Adjourn not today. You come with the case then?
Order number 23 may kindly be seen. My Lord. Page number 23 may kindly be seen.
Actually, yes, Ranga, that is middle north and middle London. So I couldn't hear.
Today you can tell them.
Today.
Obliged.
Item number 2, WPCT on of 2025.
Let I am for the. What is this?
It is writ petition, my lord, against the tribunal's order. Actively, I am not challenging the order, my lord. My lord, prior to that, my lord, I want to submit.
You are not challenging, then why you filed?
My lord, that is the reason
Yes.
I want to submit. On 8/8/2024, my lord, my original application was allowed by the tribunal, giving 3 months time for them to comply the order. When they did not comply the order, I filed contempt application. They also filed an extension application. Extension was granted till 20th December 2024. They did not comply by 20th December 2024.
Yes.
I challenged the earlier order passed by the tribunal on 6/12/2024
For?
to dispose of the tribunal application. This honorable court passed order twice.
6/12/24.
Yes. That order may be seen, my lord. That order is at page.
No, but you said the time was extended till 20th of December
Yes.
24. So what order was passed on 6/12?
6/12, my lord, that order it is at page 20. Page 20, 15 days, second paragraph, last line may be seen. Therefore, 15 days is granted to the respondent up to 20/12/24. I approach again this honorable court. It is page 22. Page 23, operative portion is page 23.
Just a minute, sir. 351. Page?
Page 23, my lord, paragraph 5, 6, 7. Only 3 lines. Order is there. Only 3 lines.
Yes, so
My lord, thereafter, my lord, kindly come to page 24, para 11.
So WPCT 50 was filed by you.
My lord.
What relief was you claiming there?
My lord, I'm claiming confirmation in service.
No, but why again a WPCT was filed?
My lord, at 6/12, the order was passed granting time.
So,
So my prayer before this honorable court is directing them to the tribunal to dispose of the contempt application without granting any time. That order was passed by the honorable division bench on December 12th. When the matter was taken up on 20th December, page 25, the tribunal, without considering the order passed by the honorable high court, again granted 1 month's time in my contempt application. But we are suffering for the last more than 23 years.
yes,
Miller, only one point, Miller. Last point, Miller. Kindly come to page 16, Miller. The tribunal's order. Sorry, Miller, page 15. First paragraph. Last 2 lines may be seen. T. Lina, Miller, got it, Miller? T. Lina was also granted first MSCP, second MSCP by order number so and so dated 22/8/23. Lina was appointed along with us. She was granted the all benefits.
appointed as
Appointed as junior engineer. So that benefit was granted to her long back, my lord. We are suffering for the last 23
and who is the competent authority to grant the issue the order?
It's the chief secretary, my lord. My lord, I hope and trust that the tribunal, it is fixed on 21st. The tribunal again will grant time. We are suffering for the last 23 years, my lord. Kindly appreciate this. No promotion, no MSCP, no confirmation, no GPF, no gratuity, nothing. Nothing was given.
And you were appointed in 2002.
29th July 2010.
These individuals basically were appointed under the temporary service rules, my lord. One of the confirmation order, my lord, is required to be the T. Lina. Perhaps T. Lina's case, the administration felt that was erroneous, but because it traveled up to the Supreme Court, we have to
No.
give similar treatment to these people as well. So, my lord, the file has been processed, my lord. All that the tribunal has done, my lord, the tribunal will have all the documents, compliance affidavit, etc. before it. We are not saying that we will not comply. It is being processed, my lord. If the tribunal's hands, the honorable court had also said, do not grant unnecessary adjournments. Then, my lord, that much, my lord, judicial authority, but tribunal is acting as a court, my lord. So, my lord, that much.
5 months is not enough.
My lord, file is under, it has been processed.
What is this big process which is taking months together?
Because, my lord, the chief secretary will also change, my lord.
Whoever it is, that is not the concern of the petitioner, neither the concern of the court. An order is there, not appealed against, it has to be complied
It is
with.
being complied.
It can't be kept endlessly like this.
It is being complied, my lord. I have
You
taken
please get instructions on Monday, you inform this court. We are not going to tolerate this.
At least till 20,
Sorry.
my lord may say 20.
No. Monday, you come back with instructions on Monday. What is this? This can't be done like this. It can't be at the sweet will of the authority to sit over the order of the tribunal endlessly like this and get extension after extension. You are for the administration. Mr. So and so and senior counsel submits that he would come back with instructions. So we only hope that some
Number 4, indemnity Arbitral on of 2023. And
I'm appearing for the petitioner in this case, my lord.
Your Lordship, I'm appearing for the applicant, Your Lordship. Your Lordship, the opposite party was the appellant. They had preferred an appeal before this honorable court, challenging the arbitral award under section 37 of the Arbitration and Conciliation Act. After preferring the appeal, they had also filed an application seeking for stay. The stay application was allowed by this honorable court on a condition that the arbitral award amount has to be deposited before the registrar of this honorable court. Accordingly, the opposite party appellant had deposited the said amount before the registrar. Consequently, the appeal before this honorable court was dismissed. Thereafter, the appellants preferred a special leave petition before the Honorable Supreme Court. After preferring the special leave petition before the Honorable Supreme Court, that application was also dismissed by the Honorable Supreme Court, and the arbitral award thus attained finality. Now the application has been filed by the petitioner hearing in order to release that particular award amount that is with the registrar of this honorable court for the benefit of the petitioner. That is the award amount.
Where is the order under which the deposit was made?
Your Lordship, Annexure P1, Your Lordship.
Your Lordship, I received the CAT application today. We will use our opposition,
You will?
file our opposition to the application, my lord.
What opposition? You have not succeeded up to the apex court. What opposition now?
My lord, steps have been on instruction I am submitting is taken for filing review petition, my lord.
Your Lordship, mere speculation that a review petition will be filed does not create a bar before this honorable court, Your Lordship.
My lord, the SLP was dismissed on 21st December 2020. Recently, so time for review is there, my lord.
Award. Lordship.
This is the direction in the award. What was the award?
Your Lordship, the award amounted to 7 crore 86 lakhs something, Your Lordship. And as per the direction of this honorable court, the award has been deposited with the registrar. And after the said amount was deposited with the registrar, they had challenged the said award and it was dismissed. Their application challenging was dismissed. Even the Supreme Court had dismissed the special leave petition. And henceforth, the award has attained finality.
My lord, some more time may be granted, my lord, so we will complete exhaust the remedy of review also.
Arises out of contract.
My lord, construction of port,
Construction of,
harbor, jetty, my lord.
there is any execution proceeding also.
Yes. Pending before the London district judge.
So then your execution proceeding will become infructuous.
Your lordship, it has been mentioned, your lordship, if the said amount is released by this honorable court, the execution petition shall be amended accordingly.
What amended? You will be, your reward will be satisfied. Where's the question of amendment?
If the award is satisfied to the satisfaction of the petitioner herein, your lordship, then the
The
petitioner will take.
entire award amount has already been deposited, so where's the question of if and but?
Your lordship, the said amount is lying before the registrar of this honorable court, your
That's
lordship.
not what we are asking you. We are
Lordship.
saying the entire amount of award has been deposited.
Your lordship.
If this court releases it in your favor, what remains in the execution proceeding?
Your lordship, then that execution proceedings will be then appropriate
Infructuous.
steps will be taken.
What
with
appropriate
regard to
steps?
that.
It will become infructuous. Nothing will remain. The order under which the deposit was made says it is a amount is being deposited for the purposes of stay. It does not say that in the event of dismissal of appeal, the amount shall be handed over.
Your lordship, it was a precondition for stay, your lordship, that the amount.
You don't, you think we don't understand that? We understand that. We are asking
Yeah,
you
lordship.
different query. You are making the same submission again and again. It clearly says it is for the purposes of a stay. Execution will not proceed till disposal of the appeal. That means after disposal of the appeal, the execution will proceed. What will remain in the execution if we give the amount to you right now? Whether they file review or not, that's a different thing. We are not on that. That they may file, whether that will in any way keep the execution proceeding in abeyance. Unless there is an order in a review, that is a different thing. But what will remain in the execution? You have filed the execution, it is pending. So whether it is to be paid right now or let him file an opposition as paid by learned counsel for the respondent. 1 week is allowed for filing affidavit in opposition. Less in the next. Yeah.
Number 5, MAT 47 of 2024.
Yesterday, we argued, rather, my adversary has said that these two appeals and the other connected appeals carry the same question of facts and law, and those appeals have been ended with an order of dismissal. The same reasoning has to be assigned even this for these appeals. I would say no, Lord. I have something more to say, which neither the coordinate bench of this court has considered, nor the honorable single judge. My lords,
It is of 5th August.
it's of 5th of August, yes. May I place it? No.
After November 24. This is the order passed in respect of the others. I think.
All the total 7 writ applications were there. The same. I for others,
All legal heirs for foreign mandal.
surrender.
But-
All other legal heirs.
Not, but the issue
Issue is
which
the
I have raised, no,
same.
I have raised the issue, but there is no, not, the single judge has passed the order impugn on a remand. A coordinate at the first instance, when the writ was moved, no, it was dismissed. An appeal was carried. Now, this court remanded the writ petition for de novo hearing on the ground that the points which are asserted in the writ petitions were not addressed by the single judge. It is on remand, the single judge for the second time passes an order impugn which I have asserted here. Now, in the writ petition, I have raised a specific ground, my lord. Now, the scheme in question, 87 scheme in question, under which I am claiming benefit, do not put any legal embargo that if I own a piece of land in a different village, I am not eligible. Rather, the scheme within its fold clearly stipulates that not the benefit can be extended one who have any other property in a different village. This point was urged, but the writ court never addressed on this.
It was from the writ petition that you filed when you stated.
Yes, my lord, I'm giving you the copy of the petition. My lord.
Which paragraph?
I'll just take my last slide. Now kindly turns to page 8, paragraph 13. These are the grounds formulated to challenge the order of the Deputy Commissioner. The last ground is at page 11, Roman 3. Roman 3. The Deputy Commissioner, North and Middle Andaman, erred in saying with a impugned order that the writ petitioner is an inheritor of his grandfather landed property is not eligible to have regularization of subject land as per the scheme of Regularization 87. The respondent misinterpreted the very object of scheme of regularization 1887. Now, my lord, I'll place this scheme. My lord, kindly have a look to this scheme.
Yeah.
My lord.
You have not made any submissions in this regard before this new event.
It was argued. It was argued, but the writ court said,
What is that? Let us,
I'll show that of the finding of the single judge. I'll show that.
is this submission regarding the 87 scheme not stipulating any bar?
No, I'll just show that. I'll just show that.
What is that?
I'm just saying.
There in paragraph 8. Where is the scheme? Let us see.
I've just handed over. I've just handed over. Kindly, I beg your pardon. These schemes are there some markings. Kindly, kindly have a look to the scheme. Rather, the scheme comes to my aid. It provides a provision. I'll just show that. Kindly turns to. I'll just take Manos to. It's page third. Clause 5 of the scheme may kindly be seen. Clause 5 of the scheme and Roman 2. Clause 5, Roman 2. If the applicant are in unauthorized possession of any land in Andaman Nicobar Island on the date of his alleged encroachment, he shall be entitled to relief under this scheme only to such extent that the total of the area in his unauthorized possession and of the areas for which an application for allotment under the scheme is made does not exceed 200 square meter in urban area, for house site 350 square meter in non-urban area, for house site, or 1 hectare in non-urban area for agriculture, as the case may be. Similarly, if the applicant has encroached on several patches of land at different places not contiguous to each village, each other, or at different village, he shall be entitled to relief under this scheme to the extent of 200 square meter or.
So how much land do you own?
No, I'm just not this. I'm facing.
The only issue is to be seen how much land you possess.
I
Let
have
us see.
inherited.
Let us see what have you said.
I have inherited 4.05.
Please come to the readings. Where have you said? How much land do you possess? You have taken us to the ground, but what is the factual foundation? Let us see.
But in the writ petition, I've said that I'm a landless in terms of the scheme.
Is the wrong submission?
But Lordship, under the scheme, I have not been given any land. That's my point, because the scheme says, kindly appreciate one thing.
It does not say under the scheme.
It says if you are possessing lands to a particular extent, you will get some up till a particular extent.
My
If
lord.
there is a gap.
My lord.
You have not said anything.
But not so, not, I have not kindly appreciate one thing. Fact remains, we have a property, ancestral property in the
You
same
don't
village.
know, neither you know.
The authority have used their
You
opposition.
yourself don't know where is the question of the court appreciate.
No, kindly appreciate the authority have said so. No, the authority have said so in the petition, their opposition, that we own a property.
In the same term.
So this issue were not thrashed out, not kindly appreciate, not this.
We have heard.
Item number 6, committee 48 of 26.
Same order. Same.
That also it's para 12.
Same, identical. Everything is same. Just names are changed.
Report order is also para 12.
Yes. Same.
Item number 7, committee 54 of 24. Item number 8, committee 54 of 24.
This honorable court has directed the Kota Municipal Council to, there are two sets of directions, not one. With regard to the demolition, we have to demolish the unauthorized. Sorry, I'm sorry, ma'am. We have to demolish the unauthorized portion of the building which was constructed by the appellant over here. We have complied and we submitted a report. During the process, my lord, the appellant, the subsequent next item, my lord, the Matama being the mother of the appellant, she filed a complaint saying that the private respondent who was initiated writ petition also violated certain portions because he has been an unauthorized portion. So the court directed us to conduct an inquiry and pass an order after giving opportunity of hearing in terms of the rules. We have done, my lord. I filed my complaints to that extent, my lord.
Copy has not been given to. Copy may be given.
The complainant.
Your Lordship, we have mentioned before this honorable court that the writ
No, so
petitioner-
therefore you are the complainant. You were,
Yes.
your structure was demolished. You said the other one is also,
I was in
illegal.
opposition. Not,
that is issue,
Yes.
that issue is closed.
Yes.
What was your status is closed. So that is not relevant.
Yes.
You said he is also in
Yes.
wrong.
Yes.
Now they have submitted a report.
Your Lordship, because order is there by this honorable court that if they are in violation, that also has to be demolished. So they have
No, no,
submitted a report. Let
Not
me,
demolished. They should take action. in terms
let
of
us see the order. Your Lordship.
Rules.
Rules.
Where is that order? In compliance of which the report has been filed.
Your Lordship.
It is of 3/10/24.
Yes, my lord, 12
November
November
2020.
2024.
There are 8.
Yes, paragraph 8 is relevant. Now they have simply passed the order.
We have
and
mentioned,
keeping
my
the
lord.
order with the
Can we read the order?
Yes, ma'am.
Yes. What did you find?
No, we find that the portion which is occupied by the private respondent is also to be demolished, my lord, because the plan which is sanctioned, it is consists of 140 square meters of land, which is jointly recorded among the appellant as well as the this private respondent. But the plan while sanctioned, they have to structure the old structure and they have to construct the new one. But at present, it is found that it has not been they removed and they made a construction. So it has to be removed. Now we mentioned it within 16th of this month. As per the regulations, we have to give an opportunity to demolish themselves. When they are not doing it, then we have to forward the file to the chairman. After approval, we have to execute and the cost has to be incurred from the person who is occupying the illegal authority.
Normal procedure mostly.
Yes,
all the-
yes, yes.
Demolition order was passed.
We have passed an order, my lord, and intimating that within 16, he has to remove the unauthorized.
I filed the statutory appeal before the appellate. Immediately after that.
No, that is not the matter, the subject matter of the present proceedings.
No, appeal is pending.
Your Lordship, being the appellant, I want to make some submission, Your Lordship.
Your scope is over now. Now it is for him to defend whether the order is as per law or
On
not.
the basis of my complaint, so I have to place the, by by which this honorable court directed the municipal council.
That we are reading paragraph
Not
8.
only 12.
Paragraph,
after that also.
yes, which order?
After 12,
Yes.
18th November, the order was passed. 18th November, paragraph 4 may be seen.
Terms of order dated to.
Terms of the judge order.
Yes.
Then it was repeated on 5th December also.
So therefore, it is now for the court to see. You have nothing to say now in this matter. What is the extent of the illegal structure? What has to be done? It is
They
between
have
them.
already passed the order.
Now
The
between
order has
them.
to be implemented.
Now it is between them. Now you have no say.
But my father obtained building
But
permit.
just
We don't know that. We are not hearing that issue.
No, I filed the appeal made against the.
So we are not going to hear your appeal. That is what we are saying.
No, appeal is pending before the.
So why are you arguing your appeal here?
Correct.
You cannot argue your appeal here. That is what we are saying.
The appellate authority may be directed to dispose of the appeal.
And where is the provision for appeal? Let us.
32.10.
You filed your show cause under 32.9.
Yes,
The final order has been passed
Yes,
under
that-
32.9.
opportunity of hearing was given.
31st December 2024 order was passed.
Then the law has to take its course.
My lord, I filed the appeal on
When did you file it?
6th January.
You
This
don't
original.
first.
6th
Tell us.
There's no stay.
6 January is all right.
Within 15 days I have to file, within a week I filed.
Yes.
But there's no stay.
So now they will have to pursue their remedies there. 32.9 is
Law is settled, your lordship. Unless and until there is a stay, your lordship, the order has to be implemented.
so it is pending before the
Being the first appellate authority.
appellate authority is deputy commissioner.
Deputy Commissioner.
Since 6 January it is pending.
I
When
filed
They
it on
file an appeal 6th.
6th. So you ask him to expedite the appeal immediately.
Not the deputy commissioner being an appellate authority is not a party. If Melodis passes an order, they will hear out because PBMC is being a respondent over the appeal. So they are filing appeal before the appellate authority. We are as a respondent in that appeal.
The deputy commissioner is not in this proceeding.
Yes, Melody is not as a party. I think.
He should come with
So
a
you-
stay order. Without
so
that, your lordship, order has to be
Let
implemented.
him dispose of the appeal.
Yes, Melody can.
Yes. Yes. Take down. Yes, what do you want to say?
Your lordship, my submission is that there is no stay order. So
That
order
we are
has
not
to be
saying that there is any stay. Who is saying there is a stay?
Order has to be implemented, your lordship. Let
Who
me
is saying
complete.
not to? Who is saying not to implement?
That is only my submission.
It
That's
will
it.
be, that's why we said the law will take an appeal. There's a provision for seeking stay. He will move a stay. If not, they are required to proceed if there is no stay.
That's what, Your Lordship, they are.
We are not
asking
here, we are not
nothing.
going to monitor this thing in a writ proceeding. Now it has to be, the law has to take its course. There's no question of monitoring. In your case, what preceded demolition order?
Same thing, Your Lordship, they filed the complaint.
They
They were
filed
not
the-
doing anything, just a minute, sir. They were not doing anything. So on the basis of the order of this honorable court, they started the demolition.
No, no.
Appeal was filed.
ठीक है, वो-
Because municipal council was not doing anything despite their complaint.
Yes,
So they filed a writ application. Direction has been given to them to do the demolition.
yes.
Started the demolition.
Without, and you did not prefer any appeal or any?
Appeal, everything, Your Lordship, it's pending. Appeal was
No, no, no.
pending.
First appeal was
Yes.
dismissed, Manoj.
My
Dismissed.
for the lieutenant commander is pending, still pending.
This court has directed the appeal.
Second provision is there.
That I have seen, that we have seen. So your appeal was also dismissed.
No, second appeal before the lieutenant governor was pending.
Your appeal was also dismissed.
Yes. First appeal was
After,
dismissed.
and you want that he should not get the forum of appeal. His demolition should take place right now, just on the basis of an order passed under
Because he
3.29.
created a stay order. That's what I'm submitting.
Is it
Provision.
lying there for him to go and take the stay order?
He
It
should,
is not lying on the table for him to go and get the
he
stay order.
should file an appropriate
That this is
application.
the only way. How do you know an appropriate application has not been filed?
Because what has been given before this honorable.
He is not required to.
The appeal is
The
there.
parties are agreeing that an appeal has been filed. They will proceed in accordance with law. Where is the question of any monitoring or
I pray that appropriate order may be passed, Your Lordship.
what
Because I
appropriate?
can't do anything now.
What appropriate order? What
This
appropriate
was
order?
the appeal.
That is what we are saying. You are unnecessarily making these submissions. Yes,
My submissions may be recorded.
yes, Federal Council for the. You are
Anything not in the list?
Worship, item number 3, vote number 2. There are significant matters before this honorable court. I made a submission for vote number 2. Whatever this is said to make the submission before this court. That item number 3, vote number 2, maybe from vote number 2 to this court, release. This is the mention in it. Yes, you. CRR 56 and 57 are, we have reviewed this court. CRR 58 by mistake has gone to that court. And that two matters are already fixed on Monday here. Before this honorable, before this honorable. I have told him, worship said that.
You can request him, yes.
I said that make the same submission before the senior.
No, you, please, he will have to release the matter, it is on his list. Unless he releases it, it cannot, it will not be proper. You should be knowing these things, yes.
Any mentioning in the list? Item number 1, WPS 625 of 2024.
No, I am for the petitioner.
No, I am for the respondent number 3, Port by Municipal Council. You are for the petitioner.
Sorry. What is the number of?
You want us to be confused?
No, but we are having the habit of standing there, my lord.
Why?
From beginning. Respondent always this side, my lord, safe side, he used to say there.
Oh, petitioner on that side.
Yes.
Because petitioners will go on changing. The respondent
Remain same. That is the reason why we are having habit of standing there. So it is better, my lord, changes.
If that is your precedent, I will go by it. I don't mind.
My lord.
This net remains almost static. The other.
Yeah, the government side is same, my lord. So, litigant will keep changing.
So from that side, it is easier to come and go.
That is the habit, my lord.
Let us do it the way it is supposed to be. Yes.
14th November, this album is going to pass the order, 14th November or maybe similar. Outside, my lord, hotel was constructed. And municipal council also passed the demolition order. This under report sealed the hotel. Municipal Council also passed the demolition order. Long back, 2011.
Yes, so filed, opposition filed.
Not fair.
But I am appearing for respond number 3, not based on my complaint only.
No, no, where is the fourth respondent? He has filed his opposition. Who is appearing for the,
It's appeared on earlier.
huh?
So Samantha was appeared with.
Where is he? Ask him to come. Affidavit
It
in
is not
opposition.
today. It is coming as under the heading to be mentioned, my lord. Let it be not today.
Period is already over. Long back.
And who are you?
Complainant. But, kindly come to page 18, madam.
Why it was there was a direction to list it under the heading to be mentioned.
Send the matter because time.
Time has lapsed.
Yes. Actually automatically listed.
Ask him to be here. We want to know whether he will file opposition or not. He's already representing the private respondent number 4. If he is not, we can proceed to dispose of the matter
I will inform you
tomorrow
Monday. It
as paid list on Monday.
Since the private respondent is not appearing.
All right, since private respondent number 4 is not represented in today's
Yes. Please.
Who speak this?
yes.
My lord,
So the
this is
service
a
is incomplete.
tender matter, my lord. The tendering authority is IOCL, my lord. So without them appearing, my lord.
No, at first we want to understand the service is complete. So what are you are for the this private? You are for
Petition.
Hmm. Why the petitioner should send it to the IOC?
Not that guy's affidavit reply meaning the rejoinder. She has serviced the rejoinder.
So is the Asman ex-serviceman security service.
They'll file the rejoinder, my lord.
So why it has been sent to the IOCL?
IOCL's opposition, the rejoinder to the reply filed by IOCL, my lord.
So it's what I sorry, I have not understood.
They have IOCL has filed an opposition.
Correct, they are the respondents.
They are in response to that, they have filed a reply.
Yes.
That reply they have sent by courier to IOCL.
To IOCL, okay.
Instead of their lawyer.
For service.
Perhaps because lawyer is not appearing, I don't know.
Yeah.
The man is appearing. Okay.
You have instructions.
No, they have filed their reply.
Post क्यों किया मैम को दे दो.
Yes, I have not got the copy of the reply. Yes.
What is the issue? What is
IOCL has had floated a tender. IOCL called upon the respondent number 2, which is my client. That is Rashtriya Sainik Board
for providing
for providing a list of the empaneled ex-servicemen security agencies. So in that, my lord, a list was provided by us. The petitioner is saying that the list is incorrect and the tender should have been awarded to them. As a matter of fact, the matter has proceeded further. Tender has already been awarded. Interim order was rejected.
So that's all right.
So today, effectively, my lord, I don't know what survives in this matter.
No, but even otherwise, apart from IOCL, I think it is perhaps the Director General of Rehabilitation. They accredit the ex-servicemen and the persons who create the panel
Here, my lord, that signing board was called upon to provide the list. So we provided the list that we maintained. Because some digital signature, etc., was called for from the various ex-servicemen security agencies which are operating in the islands. So there was a delay on the part of the petitioners. So they didn't initially feature. Later on, we added their name. But out of the list of 6, I think around first 4 or something was considered. And their contention is that the list is improper and that this requirement of empanelment was actually erroneous, and that the signing board is not competent to give that empanelment, and they are challenging the decision of the IOCL to award the tender in favor of a particular party. That party, I don't know whether is being served. That party is not appearing. That is also a problem.
So what survives if the contract has already been awarded? And another aspect is you may inform your senior therefore that if the writ petitioner alleges there is any infirmity in the empanelment, the IOCL would not be responsible for that. They are to rely upon the panel as forwarded and duly certified or accredited by the board. So therefore, you ask him to address on this issue. As prayed by Learned Counsel for
And the private party has to appear, my lord, eventually.
That will come later. See, the grievance is that your accredited institute or the persons are not deserving persons.
Yes, my lord.
And they have participated and they have benefited from the tender process.
My lord.
So IOCL, what has IOCL to do?
Yes, my lord.
If your list is incorrect, then only if they can make out, then there may be an occasion to issue notice to the
Right.
private respondents.
Well,
Otherwise, yes, Learned Counsel for list this.
I pay for.
Monday. Wednesday. As prayed, list on, give the date of Wednesday.
Obliged, my lord.
my lord, this matter, my lord, I had requested yesterday that I may be, my lord, excused. And they have accepted my advice and
I have been
He's
engaged,
been engaged for
filing my
this.
Wakalatnama, because he has been sued by name. The Tahsildar has been sued by name. I require just 2 days' time. Maintainability point, other matters needs to be gone into.
How can you file a
It can't
340
be done,
petition
the
separate?
way it has been done.
Now read the provision. Yesterday you did not have the provision. Read the provision.
Can't be done.
Read the provision, sir.
My lord,
By making a submission, it will not become acceptable. It will have to be supported by the provision. So let us read the provision. Yes. No, you may not read if you don't want. The court will proceed. The court will proceed on its own perception. How can I direct a counsel what to submit? I cannot. I can only say that I consider this to be relevant. If you want to place, you place. Otherwise, I'll proceed. Yes.
This point was raised by Honorable Judge my lord last time also. Being satisfied, he should have Sogas notice, right? Order with 14 now.
Then you have a great, probably have a very good proposition. Let us see.
Yes.
C 340 only contemplates a pure court proceedings. That is all. And if there is any impurity in the proceedings, it is to be pointed out to the court. And it must be done in the court. And if it is pointed out to the court will issue a direction under for initiating proceeding under 191. Now you say that all this is over. Now I will file a fresh proceeding. It is. The contempt is disposed of.
No. Yesterday I submitted some wrong thing before this court for that. I'm very sorry to say that.
So let us hear the correct thing today.
Yes,
Today I make the guide thing.
Yes.
Kindly come to Miller, page 10 first.
Yes,
5 minutes time may be given, Miller, I will satisfy.
your clock has started. Yes,
5 minutes.
yes,
Passenger pass on order, Miller.
Yes.
Me.
Yes. yes,
Five is happy.
yes,
Page 11 may be seen, Miller. Last 2 lines.
yes,
Hence, Tahsildar Port Blair is directed to be here by considering all the facts of the proceeding using prior notice. Notice kindly take a note, no notice was given.
yes. This you have already submitted yesterday.
This was submitted, but the track was changed little bit. Thereafter, the Tahsildar kept pending for 3 years.
All right,
Kindly come to page 12. I approve this honorable court for disposal.
all right,
This honorable court directed Tahsildar to dispose of.
yes,
Tahsildar failed to dispose of.
yes,
I approach again this honorable court,
yes,
page 13.
yes,
In the contempt proceedings, he filed on false affidavit.
yes.
Not kindly see the order.
He filed a false affidavit saying that I have heard
Complaint.
that after hearing I have complied.
Yes.
After considering the submissions,
Yes.
I have disposed of the matter. You say that was incorrect because you were never heard.
Yes.
That aspect was raised by you before the judge considering the contempt proceeding.
Yes.
The judge has taken note of it and still he has disposed of the contempt proceeding.
Giving liberty to approach. Kindly see page 15.
15,
Yes, on file.
yes.
However, I mean, however, it is kept open for the petitioner to challenge the final order of Tahsildar record.
You challenge it, who is stopping you?
I challenge that.
Then you proceed with that.
I challenge that, but that order was satisfied.
Then where is the question of, this has already been availed by you.
No,
This order does not say that you can raise an issue under section 340 CRPC in an independent proceeding.
final concept, because of that, my structure was demolished. I'm in lower now.
All right.
My survival, position of survival is gone. I'm having 5 members in my family. Now there's no scope for.
Now come to the proceeding, now come to the CRPC.
Oh, madam.
Yes, yes,
Kindly come to page 16.
yes,
This is update of complaints filed before this court.
in the contempt proceedings.
No, in WPA 124 of 2024. Stating that order was already complied.
In 124, where is 124?
This complaint was filed in contempt. It
Yes,
is one of the annexure in the contempt application.
WPA is contempt proceeding.
No, WPA is repetition. In
Then,
the contempt proceeding, this was enclosed by the Tahsildar.
all right, so that is what you have placed at page 13. That is the order wherein this compliance report has been taken note of.
Minor.
On June 24, 2024, the court took notice of this compliance report
Yes.
and it said that all right, everything is over. You said that no, I have not been heard. He is making a wrong submission that I have been heard. The court says, all right, if that is the situation, you assail the order.
The order, you got the order in my favor.
All right, that is all you have already submitted. Now now the facts are in correct compass.
That comes to only one point.
Yes.
Come to page 18.
Yes,
This is the order passed by the Tahsildar without giving notice to me.
so how does it make any difference?
Difference,
The court has accepted in the contempt proceeding that it may be without hearing you. If it is, you assail it. It remains the same. Whether you,
This order,
yes.
this order was set aside by this.
Now read the CRPC. Let us come to CRPC.
This order was.
Yes, give the CRPC.
Then order was already set aside by this court.
All right, let us see. Come to 340.
299. 270. 270. 379. 379.
Of
Of the new act.
Of the new act.
BNSS Act.
where is the BNSS? Give the BNSS. BNSS. Bharatiya Nagrik Suraksha Samhita. That is the name. What is the provision in this?
379.
Yes,
Is not mentioned in that section 379 during, it should be pending proceedings.
in that court.
That could be.
In that court. This is not the court. That court is over now.
Not over, my lord.
Yes.
Separate application in contempt proceedings.
All right.
In contempt proceedings,
You can-
and kindly see, my lord, coordinate bench passed the order.
Yes.
14 November.
Yes, what was the order?
Kindly see, my lord.
14 November.
My lord.
To file a reply to show cause by my client as to why a proceeding under section 379 of BNSS cannot be initiated.
It becomes-
There is an order.
It is an order.
Then you file it. Then you
Yes,
file it.
but-
You can check whether you comply with it.
Yes, ma'am.
When will you file?
Next week, any day, Monday, Tuesday, and I'll come with the reply to show cause.
As submitted it as Mr. So-and-so has entered appearance on behalf of
Five. Yes, that is the. During the order is mentioned that I have to file exception. But copy of the complaint has not been given.
No, we have given. Never doing it. No, we have given, we can give again notification. I'll give again, no problem. हमारा copy दे दो, मांग लेना.
where it has been mentioned.
25 September order.
मांग लेना जी.
Compliance also filed by the tax to the record, additional seats. Assistant to the.
It took you 4 months to realize that you have not been supplied a copy and it has been taken up 3 times in the meantime. Copy of the compliance report.
Scan में दे दीजिए वो नीचे. अच्छा नहीं ठीक है.
Item number 6, WPR 137 of 2020.
In this matter, the creditor has proceeding for officials on
Not today.
Sunil Kumar.
Item number 7, WPF 409 of 2022.
Lords, in this matter, my lords, there is a preliminary issue, my lords, as to maintainability, because my lord, they have sought directly, they have approached the Honorable High Court instead of approaching the Central Administrative Tribunal. And in fact, my lord, they had earlier approached the Central Administrative Tribunal. The Central Administrative Tribunal directed us to consider a representation. That decision has been challenged directly in the Honorable High Court rather than approaching the CAT. So, my lord, there is.
Seems to be fact, your lordship, that this particular establishment is notified under section 14 of the Administrative Tribunal Act 1995. I have nothing to say. My right application may be dismissed on the ground of maintainability on his submission.
The same.
That's what, let me, sir, because you have raised a point, so I am replying to it. These people are seamen. They are working as seamen and their promotional post is up to the post of Dek Sarang. These
Up
posts,
to the post of?
Dek Sarang. No, your lordship, these persons, they are not governed under the CCA rules. They are governed under the Merchant Shipping Act 1955. So
Yes.
whether this is notified under section 14 of the Administrative Tribunal Act 1985,
But
has it been?
You have approached the tribunal earlier.
That was a mistake with what we have done. Tribunal has simply ordered a simple direction, consider a representation.
No.
Adjudication on merits.
Even if CCA does not apply, that does not mean that their matter will not be amenable to the jurisdiction of the
It needs
tribunal.
to be notified under section 14.
So that is the issue, whether CCA applies or not, that is hardly relevant.
Relevant.
No,
So if it's notified, it's.
Show us that it
This
is.
is not a question. The respondent admittedly is the Directorate of Shipping Services, Andaman and Nicobar Administration. Question on notification arises where there is a issue as to whether the employer is covered under the CAT or not. Here it is, that is not the issue. The employer is the administration.
Oh.
So there is no doubt as to the fact that employer is covered by CAT.
Then it-
If they are anticipating an argument that maybe you're contractual, but then the contractual people approach the CAT.
Oh, no, that is settled. They
Yes.
will.
Yes, madam.
They are not
Your,
contractual, they are permanent seamen, your lordship.
the ED.
Yes, madam. Absolutely. And
Lordship, there are two parts,
Every day.
lordship.
no, no,
Director of, let me
Give the
clarify
part
this
sheet.
thing. There are two parts. There are two parts, your lordship. Director of Shipping Services, your lordship, deals with people on the administrative sides also. There are employees, your lordship, working on the administrative side. There are people, your lordship, who are working in sea. For those people, your lordship, the Director of Shipping Services act like a company. I will produce all those documents. your
having
lordship.
already, they have approached, kindly see the order at page 37, my lord. सब मत बोलो अभी हम लोग को जरूरत नहीं है बोलने की। वो सब कैटेगरी के लिए ओपन रखना चाहिए, वो सब में मत जाओ। My lord may kindly have page 37. This is the order, my lord, dated 11 June 2021. Passed in proceedings instituted by the same party and between the same parties. Kindly see page 39. Application is filed to seek the following reliefs. Order quashing the orders dated such and such, order directing to promote the applicants to the post of Dek Sarang following the order passed by Director General of Shipping dated 24th February 1972. And then my lord will see the submissions are recorded, and then my lord will see at page 40. In fact, one of the objections that is even raised here is regarding exhaustion of alternative remedy. Kindly see para 5. in view of objection raised by the respondents in regard to non-compliance of section 20 of the Administrative Tribunals Act, learned counsel for applicants who seek liberty to prefer a comprehensive representation before the respondent authorities. Therefore, applicants are given liberty to prefer a comprehensive representation to ventilate their grievance appropriately within 4 weeks, which if preferred shall be considered in accordance with law. So, my lord, this representation is decided in terms of the order passed by the CAT as an exhaustion of remedies under section 20 of the Administrative Tribunals Act. And that decision on the representation is being challenged before the High Court directly. This is clearly, my lord, an act of forum shopping, my lord. There is no question at all.
Your Lordship,
They are
this
themselves
word should
approached,
not be
they have
used
got
because
an
I will
order.
clarify this thing.
Then they shouldn't.
Had it been a foreign shopping, I would have gone to division bench. Why a single bench? Because jurisdiction is with the High Court, not with the CAT.
Division bench.
That's what I'm submitting.
CAT is challenged directly, or if a writ is filed, it has to come before the single. In terms of L. Chandra Kumar, they have to approach the paragraph 99 and 100. No.
Your Lordship, there is no issue, dispute with regard to that. My submission is different, Your Lordship. My contention is that parties cannot usurp jurisdiction. Law is settled to that point. I say that tribunal does not have the jurisdiction to deal with this issue. Reasons are
Statement in the litigation that the CAT will not have any jurisdiction in this matter. Therefore, this court should take up this matter under Article 226. I'm trying to find that from your petition.
Your Lordship, not in detailed words, but I have stated, paragraph 3. Not in detailed words, Your Lordship, but I have stated. I have, Your Lordship. Writ petition is amenable. Your Lordship, my points may be, my submission may be recorded, Your Lordship.
Well,
Item number 13. WPA panel.
I pay for one of this.
I appear for official respondent, my lord. It's one number one.
Item number 14. WPS 690 of 2023 with item number 15. WPS 660 of 2023.
I appear for respondent in one of the matter. I seek 1 week time to file, extension of time to file opposition. Yes, direction is there. 1 week, yes.
Number 16. WPS 702 of 2023.
I appear for respondent.
Number 17. WPA 833 of 2023.
Community organizer. इससे related है.
The applicant is working as a community organizer. Recruitment rules are at page 27. PDIC, code their municipal proceedings. And the recruitment rules was notified in 2011. In these recruitment rules, the grade pay was notified as rupees 1900. And he was appointed with the grade pay of 1900 only by an order dated 4972, dated 30th August 2014. Page 29. My grievance is that the municipality later on realized that the pay scale, grade pay should be 4200. And accordingly, they passed a unanimous resolution and they proposed the amendment in the recruitment rules, which is at page 36. Page 36. May I read it, my lord? Page 36. After that, it has been approved by the law department, page 57. 57. Thereafter, till date, it has not been notified. We are in now 2023. And my doctor's prayer is that the respondent number 3 may be directed to take the approval of the lieutenant governor and issue the amended recruitment rules. Because until unless the recruitment rules are not amended, I will have no promotion chance. My next promotion post is committee project officer. They are fine notice. No, I am just making a submission. They have submitted a proposal. And thereafter,
Right on the basis of a file noting.
no,
That is the only issue.
question is, I have made a representation to them. My representation is pending, they have not replied to them.
That you may pursue.
No,
That you may pursue. That nobody is
that
stopping you.
is page 64.
You may pursue that.
So my question is, once I have come to know that Portfolio Municipality Corporation Council has realized that the pay should have been 4,200. And there is no promotional charge on the basis of the file note.
So once you came to know, you have made a representation. But once you came to know, can the court be invoked under 226 to issue a direction based on a file noting? That is the issue of law, which stands settled by now.
No,
There is no ambiguity in this field.
The last abilities of the Delhi Development Authority and earlier is that of the Chittor Singh.
Yes, but Chittar Singh is the leading judgment. Everybody knows. So
But
therefore,
here the question is, once I have been appointed as a judge,
that question is there, but the preliminary question is what you expect the court to do on the basis of a file noting.
that is dispose of my representation.
Your representation is
Yes.
pending, yes.
The-
Dispose of the representation.
We have paragraph 8 of the affidavit in opposition.
You filed an opposition.
Yes.
What have you said?
Said that the amendment of recruitment rule for the post of community organizer under the council was returned with the observation to route the file to the administrative branch of urban development.
No, urban development and therefore a resolution of the council. These two objections I have seen from the file that initially there was two objections. That there is no resolution of the council and it has not been routed through the UD.
Yes.
But perhaps after that, that was also done.
The regulation is there.
It was also done. It appears from
Whether
the
it has
file.
been dropped altogether, that whether I can receive, I can seek instructions.
So tell us by Monday. Find out. Let it come on Monday. As paid by Learned Council for the senior council for the.
Item 18, WPA 863 of 2023.
I pay for respondents, my lord, we have filed our opposition in the registry. I am serving the copy of the opposition to the petitioner.
Yes, affidavit in opposition. Affidavit in opposition being.
Number 19. Taken up on me.
As prayed, give the date of Monday.
Item number 20, WPA 890 of 2023.
My lord, there was a direction of your lordship, my lord, I am for the petitioner. My lord, upon the respondent number 1 to 6, my lord, peremptorily to file the affidavit of opposition, lordship.
1 to 6, my lord.
In November 14th, my lord, 2024, a direction was given by Honorable Justice Rajsekhar Mantha,
Yes, my lord.
directing the respondents number 1 to 6 as last chance to file their written
I seek,
affidavit in opposition.
I seek extension of time, my lord.
The direction was peremptorily given by your lordship.
And thereafter, two orders have been passed.
There was a direction to the legal
So
aids.
why are you referring to that order now?
Lordship, they have submitted the via electronic medium. They have submitted.
After that, there are two orders. We have to go by the subsequent orders.
Lordship.
Not mean anything. How much time do you want?
1 week, my lord.
As prayed by counsel for the
1 to 6, respond number 1 to 1 6.
1 to 6 for taking steps pursuant to the earlier orders.
My lord.
The matter is adjourned for 1 week,
1 week.
1 week from date.
I'm grateful, Lordship. I'm grateful.
Number 21. 917 of 2023.
What should my screen address for the respondent? Get the matter be listed in the next week.
None appears on behalf of the writ petitioner. List in the next week, Monday, your date.
Item number 22. WPS 695 of 2023.
In item number 22, my lord, we require some more time for affidavit of reply, my lord, filing affidavit of reply. At least 1 week time, my lord.
Time for filing affidavit in reply is extended for a week, by a week from date.
I'm appearing for
List
respond
in
number
the
1.
next circuit.
Apply.
Item number 23. WPA 100 of 2023. With item number 24, 25, 26, 27.
Mr. Jayapal is appearing for writ petitioner, just not today.
I appear for
Not
respondent.
Not today. As prayed by learned counsel for the petitioner, matter stands adjourned for the day.
Item number 28. WPA 10 of 2023.
Item number 28, my lord. Advocate in record is 3L, my lord.
Hmm?
Getting mumps, my lord. So
Oh. On account of the advocate on record being indisposed, a prayer for adjournment is made. Matter to appear after 1 week
no, my lord.
in the next circuit.
Item number 29. WPA 107 of 2023.
My neighbors.
As prayed. Wednesday. Yes, all right. Any problem?
Item number 30. WPA 6 of 2024.
The same ground, my lord.
Indisposed.
No, my lord. Please, medical bed rest, my lord. Getting mumps, my lord.
So indisposed. Yes, same order. Yes.
Yes.
As which serial? Earlier,
Serial number
serial?
30 number.
Earlier one was
28.
28, same.
Item number 31. WPA 69 of 2024.
My lord, I have an objection, my lord, on the ground of res judicata, my lord. Supreme Court has already rejected this relief, my lord, at the instance of the association and the administration. Now, an individual is seeking the same relief. They should approach the Supreme Court, my lord, in case they want to.
Ian Godavarman.
Directly applicable, administration sought the same relief on behalf of the sawmills. But the Supreme Court, my lord, by an order dated 22nd April 2019, dismissed the application.
Where is that order?
That is at page 204 of my lord, 204 of the opposition. 204 Act 209. IA number is 209, my lord will see serial number 2, interlocutory application number 173405 of 2018. Kindly, my lord will see application has been filed for modification of order of this court dated 7/5/2002 in IA number 502 of 1999 and to allow operation of affected sawmills whose license was cancelled pursuant to the said order, as also to permit the sawmills to operate by importing timber logs from neighboring foreign countries and by using agriculture and horticultural crops. We are not inclined to modify our order dated 7/8/2002. Application is dismissed. And this 7 May 2002, my lord will see at page 33 at page 41.
Yes.
My lord will see at page 33 is the order of 7 May 2002 and at page 41. My lord will find second paragraph, no fresh wood or logs shall be given to any of the sawmills or wood-based industries till fresh working plans are prepared and submitted and the approval obtained. And serial number 8 is also there on the last page. 40. The licensees of all the sawmills and wood-based industries shall not licenses of all the sawmills and wood-based industries shall not be renewed after 31st March 2003. This will not debar the authorities from cancelling licenses in accordance with law if there is no breach of the license committee by the licensees before that date. Now, my lord,
Where is this? Where were you reading this?
my lord, I read at serial number
Page 40, prior to that page.
40, yes, sir. 41 and 40. 40 is serial number 8 and 41, my lord, will
Second paragraph.
Yes, my lord. Serial number 10.
Yes, right.
This is second round. Subsequently, my lord, the Andaman and Nicobar Islands small.
So why no fresh plan was prepared?
No, I'm coming to that. So, my lord, the Andaman and Nicobar Islands Small Scale Wood-Based Industries Association filed another application with the prayer to modify the order dated 7 supply of timber or imported timber. This matter, my lord, was referred to the CEC, my lord. And
Central
the
Empowered Committee.
Yes, Empowered Committee in its recommendation dated 26 June 2008 recommended for addition of up to 5 makeshift units. And then the Supreme Court, my lord, passed an order on 21st November 2008. Kindly see, my lord, that order is at page 61. 61, my lord, at page 80. It's a long, that post title is very long, my lord, because several appearing parties. Now, page 80, my lord, will have the operative part, IA number 2208 in WP number 202 of 1995. The Andaman and Nicobar Island Small Scale Wood-Based Industries Association has filed the application seeking permission to have sawmills in Andaman and Nicobar Island. The CEC has made series of recommendations as to how the regulation of supply of timber and making available the timber to these units will have a serious impact leading to deforestation. The suggestions, recommendations made by CEC are acceptable to
So the recommendations of the CC was negative.
Yes, negative. And it shall take further steps in the matter to see that these suggestions, recommendations
Are complied with, so they have to be enforced.
And after that, the administration again made an application which was dismissed, my lord, at page 209. That, my lord.
No, but no plan was prepared.
No, the CEC from time to time is preparing the, my lord, so reports are being submitted. As per that, those reports, my lord.
The initial order says that you are to prepare a
So
plan.
after that, it was the CEC was brought into our work was then given to the CEC.
Oh, now it is whole hog to be done
Yes,
by the CC.
Yes, CEC does, and we have to implement those orders. Now, my lord, If they have any grievance, let them approach the Supreme Court, my lord. How can, my lord, separate it?
What do you want?
Yes,
This is an alive proceeding in the Supreme Court.
the matter is not barred by res judicata.
No, no,
I'm asking for, what I'm asking for,
no question of res judicata.
no question, because it's the second round of litigation.
A different party, all those things you may submit.
Here is the same party has come before this honorable court first earlier, and my representation was disposed of by them, and that order is at page 45.
That's not the point. The point is, what can you get
What
when
I'm asking for, I am asking for my registration in the forest department. I am not asking for the fresh license. What he has talked about the Supreme Court judgment, the fresh license cannot be issued.
where is your representation?
My representation is at is 38. Paragraph 5 is more important. Page 38. May I read it, my lord?
Page 38 of your
My repeat. Paragraph 3, the clarification in respect of para 6.2 of Gazette notification issued addressed to the PCCF Government of Haryana, Government of Punjab Department on 8/9/2017 and on amendment of the wood-based industry.
you want to commence the business of sawmill. That is your representation.
No, my representation is that I should be allowed to be registered because I have changed the things. I am not the same unit.
Just show from the representation where you have said that you will not carry on any sawmill activity. Just show that.
Not the sawmill activities. What they have said. Industries processing the plants operating with the main sawmill, resaw.
You want to commence your unit,
Not the same unit.
same unit.
Change unit.
Come to the last page, page 39, last paragraph.
In view of the above, I most humbly pray that the Bhiwani Wood Complex may be permitted to commence the functioning within the four corners of the guideline.
Yes.
Within these four corners.
We can't do anything.
And they have to dispose of my representation.
This is pending.
No, they have disposed of.
Yes.
That is at page 45. Got it, my lord? They have rejected my representation that no fresh license can be issued. I am asking for the registration under the forest
No,
department.
you are not, sir. We have not been able to see where your request for registration.
My lord.
Please show from your representation this line that you are seeking some registration.
I am asking for.
You are submitting that you want registration.
Yes,
So we are asking you to show the
Yes.
material on the basis
Yes.
of which
Yes,
such submission is being made.
in paragraph 3,
Yes,
I have quoted the wood.
you may have quoted anything, but what are you seeking?
Let me go.
You may have quoted anything. You are not seeking any
You
registration.
are-
In view of whatever you want to commence operation, that is your.
No, in view of the above, I humbly pray that the wooden complex may be
Permitted to commence functioning. It cannot be done by them.
functioning within the four corners of wood-based.
In whatever corner, it cannot be done unless the Supreme Court is approached.
No, Supreme Court is there. Then why they have issued the guidelines?
Hmm?
Why the wood-based guidelines at page 24?
What is it?
Page 24, the guidelines.
These are guidelines of 2016. These are guidelines of 2016, much preceding the orders passed by the apex court, which are much later.
Much later.
So therefore, those orders will have to be complied. It is not a regulation which has come into force after the orders passed by the Supreme.
Why?
You cannot rely on that. You cannot.
Let me.
Just see the guideline, which year guideline it is.
Now, these guidelines have been amended further. These
You have quoted from the 2016 guideline.
2016 guidelines, they make a
Which cannot be.
amended. Page 32,
Where is the, so page 32,
amendment.
whatever it is, you want to commence operation of sawmill.
No, I want to commence the sawmill, but that's not with the same sawmill.
We don't know that, we cannot look into, neither they can nor we can look into. We cannot, neither they can.
My request is they should inspect it. If
Not at all, sir. For what purpose?
What?
When they cannot do anything, why should they inspect?
Why not? Then why these guidelines have been issued?
I'm not here to answer that question.
No, the guidelines have been issued.
We are just now running in circle is not going to help anyone.
Fine.
Again, you are coming to the guideline. Again, I will say guideline predates the order by the apex court.
The
So
guideline.
this running in circle will not help anyone.
Clearly says these are applicable.
Whatever it
to the
is, nothing
states.
can be done, sir.
Kindly, page 34. Kindly have a look at the page 34.
Yes, I have seen it.
Food-based industries establishment and regulation guideline 2000.
You want to commence operation, your representation is to commence operation of sawmill,
Within the,
which cannot be done, that can only be done by the apex
which
court.
cannot be done in terms of the apex court judgments.
Correct.
Right?
Correct.
But it can be done in terms of the wood-based industries.
We don't know.
No, if I satisfy the 4 parameters which they have given,
Just show from your representation.
why not? Representation has
Whether
been made by.
you are first you submitted, you don't want to start operation, you want registration. Then you said, yes, I want to start operation, but in terms of a regulation of which, now that regulation is of 2016. So you are shifting your stand
No, there are two things.
at
One
every,
is issuance of the license which has been cancelled. Another is the registration under the forest department. Within the.
there is no prayer for registration in the forest department, in the representation.
In the.
That which you have not sought, how can they grant?
Why not? Last paragraph.
Just show where you have sought registration.
Within the 4 corners of the guidelines.
You just show where you have prayed for registration. Don't make ambiguous submissions.
If it is not, this has been directed to you by this honorable court.
You go and approach them for registration. Nobody is stopping you.
I have already made a representation and representation has been rejected.
Yes.
Kindly have a look at page.
That representation is not for any kind of registration.
No.
That is for commencing the operation of sawmill.
Kindly have a look at their order.
Yes, let us see, let us see.
Now, second paragraph, whereas at page 47, the writ petition filed by the petitioner is a letter addressed to the divisional forest officer Diglipur regarding the permission to commence the functioning of the Bipari food mills, a food complex which has been closed in terms of the honorable apex court dated such as thus. In this regard, he has referred to the clarification para 6.2 of the Gazette notification issued addressed to the PCCF, Government of Haryana, Government of Punjab Department on 8/9/2017 on amendment of wood-based industries establishment regulations guidelines 2016 reads as under. Now, A. Industries possessing the plants operating with the main sawmill, re-sawmill or circular sawmill up to 30 centimeters shall not require any license. Industries having specialized requirement of as decided by SLC of the concerned state by using the circular saw up to 60, not using round logbooks of domestic origin shall not require license irrespective of the diameter of the circular saw. Industries processing the plants using the round lobes of the species of agricultural produce or exempted from the regime of the felling and transit regulations shall not require the license irrespective of the diameter of the circular sawmill. All wood-based industries exempted from the licensing shall be registered with the Forest Department. And as the Government of India, Ministry of Environment, Forest and Climate Change, wide their letter dated A28/2020 clarified that the clarification issued by the ministry to the state of Punjab and Haryana, wide their letter dated 8/11 and 17/11/2017 are applicable to all states and duties. Whereas in the IA number such and such, the Revenue Department of the Andaman Nicobar Administration seeking modification of the apex order 75/2002 to allow the operation of the affected sawmills whose license has been cancelled pursuant to the said order dated 7/5/2002 and also the period of the sawmill to operate by importing the timber logs from the neighboring foreign countries and by using the agricultural and horticultural produce. The Honorable Supreme Court, wide its letter dated this, dismissed the above IA by passing the order that the court is not inclined to modify the earlier order dated such and such, and after detailed deliberation, the state level committee decided to communicate the same to the forms clarifying the position and preview of the state level committee in the grant of fresh license to the sawmills. Whereas a state level committee on wood-based industries of Andaman Nicobar administration has been constituted by notification dated this of 21st June 2016 in the fourth and fifth meeting of the state level committee constituted in pursuance of the directions contained in the order of the Honorable Supreme Court in the WP number this and guidelines this. And the legal notification dated 29th June 2016. In meeting of PCCF informed the committee that MS Saha Enterprise, Janglighat and some firms dealing with the imported timber have approached the department in the order to seek clarification as to whether the fresh license for the operation of the sawmill by using the imported timber in Andaman Nicobar Islands can be used by the state level committee of the can be issued by the state level committee of the wood-based industries after detailed deliberations on the specific directions issued by the Honorable Supreme Court on forest and other mysterious matters contained in the order dated 7/5/2002 in I number 502/99 in WP number this and ever since it has been superseded by the order dated 5/10/2015 and by any subsequent order. It has now been decided that the grant of press license is not in the purview of the state level committee in the prevalence of the Honorable Supreme Court order in the matter. And whereas after going through the order of the apex court, this minutes of the meeting of the state level committee, the requisition submitted by Sri Tarun Vipari proprietors wooden based complex industries cannot be acceded to. So my request is not for a fresh license. I am not asking for a fresh license. I am asking for that I should be registered if I fulfill the conditions.
You have a license.
No, that has been cancelled. That has been cancelled in 2002.
So where is your request for registration? We have yet to see your request for registration.
Representation he has made it that is.
Where is the request for registration in that representation?
Why not in that representation?
You are asking us to read something which you have not said in the representation. That we are asking you repeatedly to show where have you claimed registration.
Yes, let me.
What registration and for what purpose? Where have you said?
Second paragraph, why not?
Yes, which page?
38.
Yes.
That on 12/3/2020, I submitted two applications, one for the issue of license.
Issue of license, yes.
Right?
Yes.
And the second for registration
Of my sawmill, yes.
I mean.
So, and then you say, I may be granted permission to operate. Where's the question? No question.
To run the sawmill. The
Yes.
point is to run the sawmill.
Correct. That's what we are saying. It is very clear. Yes. You cannot get anything. If you want the only reason why the court is waiting is if you want to avail the appropriate remedy, we can record.
Then you write me that I'll avail.
Yes. The petitioner's claim for
there. Mobilize there.
Item number 32. W 82 of 2024 with item number 33 W 83 of 2024.
But I think the respondent number 2 and 3, my lord, I filed my affidavit opposition, my lord, they have been directed to file reply.
Extension of time.
Petitioner's counsel seeks an extension for filing the reply.
Yo.
Item 34.
33.
W 90 of 2024.
Lord, in this also I am appealing for the Kotra Municipal Council.
33.
33.
एक साथ
Mobilize.
mobilize.
While my senior applies for the petition in item number 34, I am seeking for extension of time to file my report.
1 week from date. Same order, list in the next circuit.
Item number 35. WPA triple one of 2024.
The repetition will be there.
I have the list.
Our Sarup is appearing for this private respondent, 4 and 5.
They are private respondents. What is this, a writ proceeding?
Dispute between the rate petitioner and the private respondent.
You are for the writ petitioner.
Yes, ma'am. Mr. Jaipal appears for me.
Private respondent is not present,
It will be tomorrow, I will inform.
not today.
Item number 36. WPA 167 of 2024.
Petitioner is not appearing, my lord. Mr. Tabrez appears usually, my lord. Let it be next week, my lord, since he is not here.
There's some, he has not been appearing for the last 2 days in any matter,
I think out of station.
as none appears on behalf of the writ petitioner, list in the next week.
Item number 37. WPA 190 of 2024 with item number 38.
Lordship, my senior Miss A.S. Dinu is appealing for the writ petition. I seek extension of time to file my reply.
Extension 1 week from date, same order, next circuit.
Obliged.
Item number 39. WPA 207 of 2024.
You says required to file their affidavit in opposition. It is not yet filed, my lord.
Opposition has to be filed.
Not yet filed.
We have filed, my lord.
Have you served?
We would have served, my lord, but I can give him another copy. I'm giving him a copy. Copy that.
Yes, it is here,
I'll give
opposition.
him an additional copy in case he doesn't.
Copy of the affidavit in opposition is being served on the petitioner's counsel. To stop, he seeks time for reply. Let reply be filed within week from date, list in the next circuit.
Copy करके दे दीजिए.
Item number 40. WPA 224 of 2024.
Item number 40, seeking time to file my reply. I have for the respondents.
Same order, one week from date, next.
Item number 41. WPA 227 of 2024.
Raise time to file extension.
I appear on behalf of the respondents. We have already filed our opposition.
1 week from date. Next circuit. Same on
42, sir.
42 also.
Item 43. WP 254 of 2024.
Hello, item number 43, my lord, there was a direction to file a report by the Tehsildar. My lord, something is
Yes.
still going on, my lord. Requires some time.
Let us see, what is the order? Order date?
October 5, 2024. To locate alternative site.
For?
Since he was allotted with a particular land, my lord, it has already been encroached by somebody else. And
It was not handed over to me.
He was not in the
For whatever reason, it was not handed over.
alternative
And
land.
what is the date on which he was allotted? November 1980.
And he never raised any contention on that period, my lord. And thereafter, when he uh went for taking the possession, he found that already encroached, one temple is there
They did not
and
give
some
me position.
encroachments are there. And Lord, the encroachers have already filed a civil suit also. Because when we initiated eviction proceeding, before that, they filed a civil suit.
But your obligation stands. Whatever may be the situation, your obligation stands. The next.
Number 44. WP of 2024.
Lord, I appeal on behalf of the respondents, my lord, we have
My lord,
already
I am
filed a
praying for
petition.
extension of time to file a reply.
Reply.
Yes.
What is it?
File.
Let's see, what is the issue? Yes, same order extended by a week from date, next Saturday.
For a little bit 2 weeks, my client is residing in a different island.
2 weeks.
Item number 45. WP 266 of 2024.
Time for to file my extension.
Same order. 1 week. Next Saturday.
120.
Give your appearance.
Item number 46. WP 276 of 2024.
Petitioner. Taken Wednesday for hearing.
What is it? What's the issue?
Claiming the interest because I am the supplier, supplied the pathological equipments to the department through a tender process. So they cleared the payments, but delay payment was there, some claiming interest on the delay. The input order is at page number 205. The Chief Secretary. Earlier, I moved it pretty before Honorable Court.
At page number 199. This Honorable Court directed the Chief Secretary to consider.
Where is the order passed in the writ proceeding?
My lord, at page number, my lord, it starts from 197. Therefore, page number 201 is relevant. But they have not seriously challenged the claim of the petitioner to the ability of import of interest. 201. The top paragraph.
What is a mistake? Very clear.
Hmm?
That appears to be a typing error. I don't see the whole paragraph.
No, even if you are not seriously, that's now that order has taken effect. The matter has been considered. What can be done in a writ proceeding? That is what I'm trying to grapple with.
In that, since 2014, the amount was due. Since 2014, the delay, the ground is that there was a defense proceeding against the person who put a tender. So I am the supplier, bona fide supplier. I have got nothing to do with it. I supplied the thing.
You are not a very bona fide supplier. You have accepted that you have quoted exceptionally high rates, which was also allowed to be detected. So it's not a very bon, but therefore the issue will have to be examined in a proceeding. Payment of interest under the Payment of Interest Act or whatever, we don't know. Even if there is no clause, whether they can deny, whether such a provision would be unconscionable in terms of the Contract Act, that no interest will be. These are issues which have to be considered. How it can be thrust out in a writ proceeding.
But they release the amount, principal amount they release.
That we have seen, that you have already got. After getting that, you have filed the writ petition.
No,
In September, you have accepted the amount. In September 22, you have accepted the amount. In November 22, you have filed the writ petition that look, my representation for interest is pending. Court said dispose of the representation, now disposed of. Whether this representation is sustainable or not cannot be decided in a writ proceeding.
Second thing, it is registered with the MSME Act. As per the MSME Act, I am entitled to have the.
First thing first, then second thing. First thing is how it can be decided in a writ proceeding. Who was at fault? When the supply was made? What are the different terms and conditions of the agreement? Is there any arbitration clause? Whether the terms of the contract can be enforced in that particular way cannot be considered in a writ
SME council also they can approach in case.
any forum. This is essentially a civil dispute which needs to be considered with reference to various, it raises disputed issues of fact for which evidence may be required. So keeping it pending here, I don't know whether it will serve any purpose to your client.
You want to oppose the MSME to
Council
redress my grievance here.
or any other forum.
MSME is the competent authority to.
Yes,
redress my
the petitioner has supplied medical equipment to the respondent administration in the year 2014. The claim in respect of such supplies was settled in a meeting of 16/9/22, wherein a payment of 38,84,940 rupees 38,84,940 was paid to the petitioner. Stop. The petitioner thereafter has filed a representation for payment of interest on their dues on account of the fact that the payment has been made after a long delay of nearly 8 years. The representation has now been rejected by an order passed by the Chief Secretary on
December 29.
Two. Plus, it's also not apparent whether there was any arbitration clause in it.
Number 47. WPS 24, that is number 48, WPS 24.
In this case, not, the council is in bid respond. I already mentioned.
Same as 28,
Yes, ma'am.
serial 28.
Yes, ma'am.
Item number 49.
49, I am praying for extension of time to file reply, opposition. 1 week extension may be given.
As a last chance, we'll have 4 directions are there.
Last chance may be given.
Today, fifth
By way of last indulgence, time for filing affidavit in opposition is extended by a week from date established in the next circuit. If so required, the petitioner would be at liberty to place on record his reply.
Highly obliged, my lord.
Item number 50. WPS 324.
Same advocate, my lord.
28.
Item number 51.
I'm for the petitioner, my lord. In this case, due to personal difficulty, this matter I'm unable to take it today. So it
Not
will-
today.
Not today.
Okay.
It may be taken up next week anytime.
Huh?
Next week anytime. Anytime in next week.
As prayed, give the date of Monday.
Next. One more. Item number 52. WPS 342
I treat Wednesday.
I pay for respondents. Pleadings are complete.
Why? What is this?
Today I'm not ready because there are two.
As prayed, list for consideration on with the date of Wednesday.
Highly obliged, my lord.
Item number 53. WPS 435 of 124. Item 53.
53, my lord, I am appearing for the administration, but my lord, the petitioner and IOCL are the.
None appears. List in the next circuit.
Item number 54. WPS 450 of
I am praying for
124.
extension, my lord, in this.
For opposition,
Yes, ma'am.
as prayed by learned counsel for the respondent, time for filing affidavit in opposition is extended by 2 weeks from date list in the next circuit. Time in the meanwhile may be utilized for filing a reply if required.
Item number 55. WPS 505 of 124.
Respondents are referred to file opposition.
We are fine.
We pray for extension.
Same order.
Yeah. This has been filed, ma'am. My apologies.
Copy of the affidavit in opposition is being served on the petitioner's counsel in court. Stop. Let
I'll a copy.
let reply be filed within a week from date. List in the next circuit.
Please give us a copy of this Xerox. Xerox for our. You don't have.
You are obliged to give him a copy.
Item number 56. WPS 532 of 124.
I am for the respondents, madam.
Reply. 1 week from date. Next circuit.
Okay.
Item number 57. CRASB 3 of 122.
Same advocate, my lord.
28, serial 28, same order.
Item 58. Sierra 27 of 122.
Lords, my senior Mr. Govind appears for the state CBI. As of now, he is out of station. Let it come after 14th Monday.
You are for
Stay on representing Mr. Govind on behalf of state CBI appellant.
state is the appellant,
My lord, this is a revisionist.
has played list after a week.
Grateful. 16. Grateful, my lord.
Item number 59, Sierra Leone 2023. Item 59,
For the state.
None appears. Not today. Just not today, no, don't.
item 60, Sierra 18 of 2023.
My lord, my senior appeal for the petitioner, I am praying fixed for next week.
Has
For the
played,
state.
has played next week.
60 and 61.
60 and 61 both,
Steven, I'm there.
both cases. 1 week, after a week.
Item number 62, CO 40 of 2023.
Not today.
Item 63, SC3 of 2024.
This can be taken up. Second appeal, admission has been done. Paper book in terms of the direction of the court, registry have prepared it. Even I'm told that notice has been effected upon the respondent.
They have appeared.
Find anyone first. So all exercise was undertaken by the department.
No, but just as certain, then we can take it up. I will list it on Monday.
Well,
In the meantime, you find.
let me,
Yes.
let me.
The learned counsel for the appellant submits that he will find out whether the respondents have entered appearance. So, matter will be listed on Monday.
Well, subject to what my lord says, if any application is given, because civil matters normally retain the position in the down.
It will come up,
Well,
don't worry.
Second appeal.
I
scanning
don't
of
think it will
evidence.
be more than this, what we are at today.
Well.
Yes. Next, only 2 cases remaining. Then call it wise for years.
Item number 64, SN9 of 2024.
You have to submit. Due to inadvertence, it is submitted by the learned counsel for the petitioner that appellant that it has been recorded in the last order that paper books have been submitted, comma, though the same has not been submitted. Stop. For submitting paper books, he seeks 1 week time. List in the next available circuit.
Item 65, Integrity MD1 of 2024.
How should my senior ASD was appealing for the appellant and paying for extension of time to prepare paper?
I am for the insurance company. This is a
For filing informal paper